When we look at the current litigation over real estate, we have to understand that the settlement terms are now going into effect as of August 17th of 2024. There is a requirement that if you as a realtor are working with a buyer, that you have a written buyer agreement in place before you show a home or do an open house, specifically or either in person or virtual for a potential buyer that you're working with. Okay. Now you must be working with that buyer. Okay. Do understand that that's the terms. But with that said, is that you must have a written agreement in place. That written agreement must specify what you as a realtor are going to do, what services you're going to perform, and what compensation is to be paid on behalf of the buyer. Okay. The written agreement forms should be and account for the choice of the consumer and the real estate professional, meaning it should freely allow both parties to negotiate the terms of the relationship. Pre-filled terms in an agreement are not acceptable. Okay. Keep in mind, do not pre-fill in as a brokerage or as a real estate agent pre-filled terms, because that will backfire on you later on when it comes to any litigation that arises out of there, because the buyer has to have the ability to negotiate those terms. Okay. Now, that being said, there are mandatory provisions, as you can see here. By law, the compensation provided to an agent must be disclosed to the parties involved. Meaning, in this case, the buyer agreement has to specifically disclose the amount of compensation that they will receive from any source. Likewise, a listing agent must disclose to the seller what compensation will be provided. Okay. You cannot hide terms of the deal from the buyer or the seller. Okay. That, as a real estate agent, that's how we differentiate ourselves from real estate investors and wholesalers and so forth, is that we have to formally be up front and have full disclosure with our buyers and sellers. Okay. The amount of compensation must be objectively ascertainable, and it cannot be open-ended, meaning it can't stay, what the seller is offering to buyer. Okay. And that's where I see a lot of agents will get tripped up in, is because they're going to depend upon, the compensation that may or may not occur from the seller. The written agreement terms, the mandatory provisions state that it can't be open-ended. You can't have elusive terms that are not there, meaning, what may or may not occur later cannot be placed in that agreement. Okay. The participants may not receive compensation from a source that exceeds the amount that the buyer has agreed upon. So in this agreement, your buyer must agree upon a certain specific type of compensation or amount of compensation, and how that compensation is going to be paid. Excuse me, from any and all sources. Okay. When we look at disclosing in conspicuous language, remember, it has to be clearly stated. From a legal perspective, that's where litigation always arises, is because the terms are not clear. Always include any provisions by law. Okay. Now, with the buyer-broker agreements, we must also indicate that, they must be, one, clear, in readable size font, can't be in tiny font in certain places and so forth. That's, what, disclosures required. No pre-filled terms, as we discussed. The services that are being provided by the realtor to the buyer must be specified or outlined. When it comes to compensation, just like attorneys and other consultants, participants may now agree to a retainer fee and address whether the retainer is included in the total compensation or credited against the compensation and may or may not be refundable. Okay, so as attorneys in the legal profession, as we always have a retainer agreement with a client, specifying what money we're going to take as a retainer and how that will be applied towards the services that are being provided, and whether or not, if you're taking a retainer of $5,000, if in fact that transaction falls through and all the services are not provided, what is refundable? Okay. You might provide services on an hourly basis with an hourly fee. If you are consulting, that is one form of how we structure compensation. Okay. If you are doing a limited service agreement where you're providing limited services, you have to understand and state, with limited service, what services are being provided and what you're going to be paid for that service. If you provide any services over and above that, how will that be compensated? Okay. You'll have to state the agency that you're going to have: non-exclusive, exclusive, sub-agency, transactional, and so forth. Okay. The term of the agreement is always in the contract or an agreement. The services to provide it, again, you can limit to a number of showings. With buyers, basically, you might show them 50 houses. Sometimes, if they're not really certain about where they'd like to buy and what market they'd like to be in, sometimes that happens. Hopefully not. Hopefully you're able to communicate back and forth and decide up front on a limited number of homes that you're going to see and a limited time span. However, you must state what services are going to be provided. If you're doing limited service, you might not be involved in all the negotiations. Okay. You might not be there to present all offers. Maybe you'll only be there for showings through creating the contract. And then the buyer is going to take over to actually do the closing, or they're going to work with an attorney through closing. Whatever that may be, specify what services you're going to be providing. Okay. Dispute resolution, always include mediation, arbitration, something that limits the amount of time for any kinds of disputes that are involved with that, with the potential agreement. Okay. You should always have and protect the buyer for consumer protection, equal opportunity. Okay. I always included wire fraud, having a title company and being an attorney. We always had wire fraud, affidavits and so forth, just having the buyer, sign off, indicating that they realize that if they do certain things, that's considered a wire fraud, and we're not going to be involved with that. We're not going to accept that. That's not acceptable, and that is a liability for for the real estate agent, the real estate broker, and anybody involved. You must also disclose whether or not you're doing it in video or audio recording. Okay, so you have to comply with those laws. The from a real estate perspective, there are many people that are involved in real estate transaction, from inspectors to lenders, tax advisors, title agents, attorneys. There's a number of people that are involved, and you as a realtor or real estate agent must also notify the consumer that they are, they must seek professional advice from those people, and that you're not providing that advice. Okay. You must keep the lines of your representation clear from other things that you may or may not be doing for other clients. Or if they are part of your services, that is also disclosed in the fee agreement, and that you're adequately protected from liability for those services. The buyers and sellers can, or the buyers and the buyer's agent can negotiate, agree to the duration of the agreement, and determine whether or not it is automatically extended upon the closing or contract ratification. Again, you will have different levels of service and different levels of compensation for each service. So keep in mind that you must address whether or not the contract, the agreement actually continues or terminates upon certain things or milestones. If in fact, and what we have in the real estate industry is we have a lot of conflicts of interest. Okay. If you're acting on behalf of the seller and the buyer, you are a transaction broker, and you have to understand and make it clear to both parties that you're representing them in the transaction itself. Okay. So there must be a disclosure for that. And we have standard disclosures. If you are representing the seller and there are a number of buyers that are submitting offers on the same property, okay, so you will have an agreement with the seller, and then you will have an agreement with the buyer. You must disclose to them that there are other buyers and that you're not representing them in their sole capacity as a buyer. Okay. So do keep that in mind, that you must still sign an agreement with the buyer, but indicate to them that you are representing other buyers, and you do not have you're not representing them solely. Okay. And that there are disclosure requirements and non-disclosure things that you cannot allow, and that your services to that buyer are limited based on your representation of other buyers and also of that seller. If you have any questions with regard to the new regulations and rules with regard to compensation, buyer-broker agreements, and listing agreements, and so forth, we're always here to help you. Again, click the link in the bio and see the further videos on this topic.